Good morning and good afternoon to everybody. My name is Kishore and I am the event manager with Compliance Key Incorporation and would be your today's host. Thank you everyone for joining in today's live webinar, How to Manage OCR Hipaa HITECH Audit. Today's presenter is Srini Kolathur. I will quickly introduce Srini. Srini has several years of experience in helping companies effectively meet and exceed regulatory compliance requirements including SOX, PCI, HIPAA, etc. by using best practices. For the last several years, he has been actively involved in SARBOX control implementation, PCI DSS, GRC, and internal audit functions in the critical general IT control areas. Now, before I hand over it to Srini, I should inform you that the session would be of 60 minutes. Also, we have Q&A session at the end of the webinar. You can keep sending your questions through chat window and Srini will answer those questions at the end. We will begin now. Srini, I would request you to please start the presentation.
Thank you. Thank you, Kishore. Thanks for the wonderful introduction. Good morning, good afternoon to everyone on the call. Let's go ahead and get started. Just a quick plug about our company. We are into healthcare compliance and security services. What we do is primarily we do educational events like online training, webinars, and a customized workshop. And we also have do-it-yourself toolkit for people who want to get their HIPAA assessment done by themselves, primarily targeted towards small practices. And also we have consulting services for more complex setup, hospitals and multi-site healthcare practices, pharma companies and medical device manufacturers. We do have consulting services as well. So again, we just want to put this one up before we go any further. This webinar is being provided only for educational and information purposes only. And if you have any specific fact-specific situation, you definitely want to consult your attorneys. That's pretty much it. And as Kishore mentioned, all this information is available. All the webinar recording is available for you for later viewing. So Kishore already gave a quick introduction about me, and I'm going to just skip that. And here is the high-level agenda for today's webinar. First, we are going to be looking into the HIPAA HITECH requirements. The reason actually we are spending a little bit of time here is to give you a background about what exactly is the rule and what is that as a covered entity or a business associate you need to comply with, and how to go about planning your audit activities and things. So that is one, and then of course we will look into some of the recent HHS settlements and phase 1 audit, phase 2 audits that are currently going on, and what is happening in the desk audit, and also some of the key takeaways and how to prepare yourself for the audit. A lot of the things we are going to cover. Hopefully we can cover everything in the next hour or so. So here are some of the terms that you may hear during this presentation. Just wanted to make sure we kind of give you a little bit background about each of the terms that we are going to be discussing. First one is HHS. Most of you must be very familiar with HHS, Health and Human Services. OCR is the agency that is attached with the HHS. OCR stands for Office for Civil Rights, and they are the enforcement agency of HHS who get involved primarily in the HIPAA audit. If there is any violations, if there are any settlements, OCR try to get involved in, with HHS authorities on your particular case. HITECH stands for Health Information for Technology and Economic and Clinical Health Act. It's a pretty big one. It was actually introduced in 2009 by President Obama. I have a slide that talks about what all the changes that were introduced as part of HITECH Act. And HIPAA, most of you must be very familiar with that. Health Insurance Portability and Accountability Act. PHI actually stands for Protected Health Information. A lot of people confuse PHI with personal health information or patient health information. It is protected health information. I have a separate slide that talks about how PII, the personally identifiable information, combined with clinical data becomes protected health information. So that is at a very high level. Before we get started, want to jump right into the topic on the phase 2 audit, what is happening. So as you see here, desk audits are currently going on, and HHS has published a lot of information on some of the things that are happening in the on the audit protocol, and they have frequently asked questions about what kind of documentations to prepare, submit, and all this information, primarily targeted towards the entities who have been selected for phase 2 audit. So for about 200 or so organizations have been selected for phase 2 audit, and if you really look at the percentage of the entities that are selected in the whole realm of this Hipaa requirement, it's very, very, very small percentage. But still, the phase 1 and the phase 2 audit that HHS is planning on doing, or like coming up with this protocol and things, is setting themselves up for a much wider audit that's going to probably come up in the near future. But that's why actually we wanted to educate the community and make sure that they are aware of what is going on, and they have the latest in terms of preparing themselves for the Hipaa audits. And then also a couple of other alerts. One is there are a lot of phishing emails being sent out by third-party agencies, totally not related to HHS or OCR agencies, communicating that, hey, the emails, you've been selected for audit, and here is how we could help you with preparing for audit and things. So they have a separate publication on this particular one. If you, all of them are hyperlinked. Actually, Kishore will be sending out the presentation deck as well. So most of these are hyperlinked. You can click on this and go to the specific site and look into the details of each one of them. And then the third point here is they are not going to be posting the listing of all the entities that they are auditing. Freedom of Information Act, you could invoke and you could still request for some of the information, but they are going to be definitely sharing high-level information about the audits and what is really happening and what is their learnings and stuff. Sorry about the formatting issue here, but definitely you get the point. So this is what I was talking to you about, protected health information, and how is it different from PII or the health data, right? So the 18 identifiers that you see on the right side of your left side of your chart, when it is combined with the specific patient's health data, that is when it becomes protected health information. You are going to be under Hipaa scope only when you are managing this protected health information in an electronic format within your practice or within your organization. So if you don't have, like if you have just the PII on the left side or just the clinical data without any patient identifiers and stuff, then most of the case you are not going to be under the scope of Hipaa at all, right? So this is the first thing actually we pretty much cover in all our presentation to make sure entities understand the requirement, and also a lot of cases some of the entities who think they are covered under Hipaa, they are really not covered. So this is something actually you want to make sure you are managing this patient data. If it is, then like you are going to be either a covered entity or a business associate, just because you are performing certain functions for the covered entity, the healthcare companies. Then you are going to be a business associate, and again you need to comply with certain requirements of Hipaa. Yeah. So again, we try to visualize most of our educational activities, as I mentioned, right? So for the HIPAA federal rule, the HIPAA HITECH federal rule, like there are three primary components. First one is the privacy component, which is pretty much to do with the way like you interact with the patients and when you disclose the information and what for marketing purposes or for a third party or for law enforcement. And it's primarily more about the legal requirements of how and when you could share the patient data with a third party. And it is primarily in the paper format, right? So that's when like the privacy rule kicks in. And then there is a security rule. Whenever that data gets converted into electronic format, then there are certain requirements that you need to comply with when you're storing this patient data in an electronic format and sharing that information with third parties. So that's when the security rule kicks in. And then the breach rule is in case if there is a data compromise that is under your custody, then like you have to follow certain procedures in terms of communicating with the patients, communicating to the state agencies if it crosses beyond like 500 individual records for a particular state and all this information. So breach is only when if you have a data breach, how do you handle it? The thing is they are requiring you to be prepared to handle data breach situation. So they want you to have policy in terms of what is that, how would you go about determining if there is a breach, and how would you go about notifying the individuals, how would you go about notifying the agencies, and what is the format of communication, all those things. They want you to have that ready to handle the breach situation. So that's why the business associates, let's say if you are helping out a healthcare entity, then you need to comply with the security rule requirements and the breach rule requirements. You have very, very few requirements from privacy rule that you need to comply with, right? But primarily the privacy rule is applicable for the covered entities in terms of data sharing, the forms, authorizations, and all these things that they need to maintain before releasing information. So here, this is something actually, again, we want to make sure, if you are a business associate attending this webinar, you need to make sure that, you are complying with the security part and the breach part. And if you're a covered entity attending this webinar, definitely you also want to expand your coverage and make sure that you're complying with the privacy requirements of that as well, right? So here are the high-level changes. There are quite a few changes, but high-level modifications that happen to HIPAA. First one, HITECH Act provided a lot of money, incentive money to providers to implement electronic health record EHR systems, certified EHR systems. If the providers are going to implement in their organization, then they were getting incentives in the initial few years, about 4 to 5 years. CMS and the Medicaid agencies paid a lot of incentive money to the providers for adopting electronic health records. Of course, it was a carrot and stick policy. If they did not implement the whole electronic health record in the first few years, then they had a penalty clause. Now, most of the practices are coming under the penalty period now. So whatever reimbursement they are getting from CMS, they would have up to 4 or 5% of their reimbursement be withheld because they don't have the electronic health record, because it essentially improves care and be able to electronically exchange information between parties and between CMS and the state agencies and the provider. So that's essentially the reason they came up with this incentive policy. Then the second thing is now with this HITECH Act, business associates are directly coming under HIPAA rule. Earlier, before HITECH Act, it was kind of very vague, and so they brought the new modifications to the HIPAA Act, which essentially brought all the business associates who are doing business with the covered entities under the HIPAA rule. And then they redefined what is a data breach, given much clearer definition and specification on how to go about determining if there is a data breach and whether there was a risk to patient in terms of the data breach. So essentially need to go through a process to determine and then determine and notify the individual, the agencies and third parties, or just document that there was no risk to this particular patient because of that exposure. All these things have been clearly defined in that HITECH Act. And then the fourth thing, they came up with much stricter notification standards, 60 days from the date of discovery. Covered entities need to notify the patients. Within 60 days, they need to notify the patients or the agencies if it is more than 500 records. And if it is less than 500 records, then you need to be reporting annually to the to HHS in terms of your data breach and the reasons and things. So HHS, in fact, OCR has a portal where you could go ahead and start entering in the information. Then the next one is they tighten the enforcement. That is essentially the main objective of this webinar in terms of talking about audits and where they are and what kind of information they are requesting and things. And of course, they also increase the penalties for a violation. If you are keeping up with some of the HHS news cycle, definitely you would have come across a lot of settlements in the last few months. They are getting really aggressive in terms of, are very active in terms of settling with the covered entities or the business associates who've been found to have violated the Hipaa rule. And then actually I will explain to you in terms of how they come up with the settlement amount as well. Because they've introduced a lot of new codes and transaction sales, 5010, ICD-10, and all this sort of things. So this slide deck needs to be updated, but they paid out Medicare and Medicaid incentive money. Close to about $30 billion has been paid out to the providers for adopting electronic health records. So that's a pretty popular program, and if you are not very familiar with that, I would definitely encourage you to read up a little bit on that. And now this program is called MACRA or MIPS. Again, like they come up with more complicated acronyms, MACRA and MIPS, and definitely it looks like that is the way the agencies are setting themselves up for a success and converting themselves to a more value-based payment model versus a pay-per-service model. Here are some of the latest settlements with HHS and the covered entities or business associates. So if you, for example, the first one, if you haven't notified the patients on a timely manner, again, there was a penalty for that in the first incident. And the second one, of course, the security risk assessment was not completed on a timely manner. And third one, again, like the breach notification was not sent out to the patients on a timely manner. And then here you see like a lot of other examples. So all of them are hyperlinked. I'm not going to be getting into the details of each one of them. So they do a very good job, thorough job of publishing this information and also attaching the resolution agreement, they call it resolution agreement between HHS and the parties, clearly outlining how did they go about investigating it, when was the incident reported, how did they go about investigating that particular issue, and what is that they found out, and then what is the violation, how did they come up with the settlement amount, and then what are the corrective action plan. So that's a pretty thorough document. If you want to kind of familiarize yourself in that space, I would encourage you to take a look at that. And these are all hyperlinks again. So CMP, civil money penalties, and the settlement amounts are not the same. The way I think the way HHS wants to handle this is the parties are not agreeing that they kind of violated, they essentially get into some sort of settlement agreement. Essentially, the lawyers kind of handle the whole issue once you start reporting the data breach, and then your company's legal person, and then like HHS lawyers will start working on the settlement amount and how to go about the whole process, right? So here is the chart of the civil money penalties. So depending on the category that you fall under, you didn't know there was a data breach, or you had a reasonable cause to believe that there was a data breach because some patient called you saying that, hey, their credit card information seems to be, their credit card number seems to be used outside as well. The last place that they used is at your facility and things, or like it was a willful neglect because people have reported and you didn't do much but still corrected it, but willful neglect not corrected. So depending on the category that covered entity or business associate falls under, the violation amount is going to be decided, and the way they calculate the total amount is based on the violation and the number of records that is violated. Like let's say if you are managing 5,000 patient records, and then if all of the 5,000 records have been, you haven't conducted security risk assessment for your practice, that means the way they would go about it is the violation of that particular regulatory requirement times number of days you violated it, and based on the category you fall under, per record they will charge $100 or $1,000 depending on the category you fall under. They'll come up with this amount. As you could see, the numbers could add up very fast, right, very quickly, and then good thing is they have a max limit of 1.5 million per calendar year. So if they have kind of identified you have violated for more than a year, then again, like if it is 2 years, then again they could go up to $3 million fine, right? So the numbers are really big, and nobody wants to definitely go through this one. So that is essentially the idea for them to come up with this higher number, so that like people take this whole compliance efforts more seriously and work on protecting the patient data. And one more thing actually I just wanted to bring up here is, OCR and HHS, we've been following OCR and HHS pretty closely, and they are hiring a lot of auditors actually to go after the entities who have complained about or like who have filed a data breach report, and there are still close to about 7,000 to 10,000 complaints or the data breach reports being filed per year, with HHS. So as you could see, there is a lot of a pending case that needs to be investigated and determined what's really going on. So so they are getting really active in this space. So just to give you the overall process flow of how it works, if there is earlier pre-HITECH Act, if there was a complaint filed by a patient or a third party, then HHS and OCR, they take up that particular case, and then it goes through the investigation process, and then they kind of determine if if there was a violation, no violation, or voluntary compliance agreement and things, right? So now with this OCR audit program, they could pretty much pick anyone, anybody who's managing patient data. That's what Congress has authorized them to do, right? So they could pretty much pick anybody who's collecting patient data or processing patient data, and then say, okay, I'm going to be auditing you, and then they will pretty much go through the whole process, and then depending on the type depending on the violation category and things, either they could go to the civil penalty claims, or they could even be potentially investigated by DOJ for violating some of the Department of Justice for violating some of the rules, right? So they have a lot of information available on their website as well. Just in case if you have any additional clarification and things, feel free to reach out to us, and I will be more than happy to discuss that in detail. Here is the high-level overview of the Phase 2 Hipaa audit program. So the communication has already been sent out to the 200 or so entities that have been selected, and then HHS also sent out a pre-audit questionnaire to them to be filled out, and then based on the pre-audit questionnaire, they've kind of selected some entities, and then now they were requested to submit all the documentation within 10 days. So that's the most important thing, because you really don't have a lot of time if you get selected. So that's why we kind of emphasize that, identify the requirements that they are going through with respect to audit, and then make sure that your practice or your organization is all set to handle that in case if there is any audit. You don't want to, prepare them at the last minute. And they could also go up to the last 6 years to find out how you are complying with this HIPAA rule, and then they could even request for 2017 now. They could go up to 2011 or 2012 documentation asking, show me your policies for 2012 and show me your security assessment for 2012 or 2013, right? So that's what's going on. So desk audit essentially meaning it's a remote audit. So they are not going to be on site to do your audit. All the documentation that needs to be submitted are all uploaded to a secure site provided by HHS. You'll upload all the documents, and then they will review the documents. And then I have a separate slide in terms of what are the next steps. But then on-site audit, last time when we attended the HIPAA conference in DC, they've said that the on-site audit is going to start sometime in the beginning of this year. So we haven't got any clear communication yet in terms of when is the on-site audit really kicking off. But then they will go for on-site audit, but not like all the entities they've selected. Only selected a few entities will have to go through the on-site audit. As you could imagine, that's going to be very time-consuming effort. They don't want to put everybody, in terms of going over the whole process, and then the potential compliance review. So as I mentioned in the very beginning, OCR, first time they started this audit way back in 2014, and 2012 they've started, but it took probably about 1.5 years or so for them to wrap up the whole thing. And then they conducted this phase 1 audit on like about 115 covered entities. Only covered entities in phase 1, but in phase 2 they are also including business associates. And then second thing is they also published audit program protocol. That was like really exhaustive, though. You really need a couple of days to go over all of them. But essentially, based on the security criteria, privacy, and the breach that we talked about earlier, so they had published all this information. They might potentially look into. And essentially what they kind of identified is, there are few low-hanging fruits and few areas where the entities need to really focus on. One was the security assessment. Not everybody understood the requirement, and not everybody did a comprehensive assessment. And then the training part, they've identified few areas for improvements in phase 1. And then in phase 2, they haven't published the results yet since the program is still going on. And this is how you get notification from HHS in case if you get selected by OCR or HHS for an audit, right? This is just to give you an example. The reason being there are a lot of fake emails or email scam that's going on. You just want to make sure that you are directly getting it from Department of Health and Human Services. And if you have questions, you could definitely call them to, make sure that, the emails are originated from HHS and OCR. And I have the email ID also here, like OSOCR audit @hhs.gov. So you could email them in case if you have any questions and things, right? So again, like within that privacy, breach, and security area, here are like the subdomains that they will be covering. whether you are having notice of privacy practices for your practice in terms of how you will handle the protected health information. And then if a patient requests for protection, what is the process you have, and how do you document all this information? And then how are you providing the access to the individual? It's pretty much listed out in the privacy rule. And then how are you managing the administrative requirements, and how are you using the data, how are you disclosing it to third parties, and if patients want some amendments to their records, what kind of process you have, and then how are you maintaining logs of all the disclosures that you are making, right? So that's the privacy part of it. And then again, the breach notification requirement, they are looking primarily for the breach policy in terms of what is your practice going to do in case, if you kind of discover a potential breach, how would you go about doing risk assessment, how would you document and all those things. And then third and the most important thing is the security rule. So there are like there's 3 different safeguards: administrative, physical, and technical safeguards. They want to make sure that, like you are meeting all the requirements that are set out in these 3 different safeguard areas. So what is the update I have on phase 2 desk audit? So I think like some of them we've already covered that, and it actually started on July 11, 2016. They haven't published the results yet. 167 entities have been selected, and they have already identified the business associates who they are going to be, auditing as well. Close to about 40 to 50 business associates have been identified based on the last information we received from them. And then so I think like the first bullet point we already covered, 200 to 250 audits in total and over 200 desk audits. So all of them need to submit the documents via the secured portal, and they will be reviewing, the auditors will be reviewing the documents. And then out of that, only about like much smaller number of them will be selected for on-site audit. And, essentially the objective is to identify the best practices, what's being used in the industry, and then discover the risk and vulnerabilities, of course, the overall level, and then also being proactive, with respect to some of the issues that are happening of late with respect to this data breach. They want to be proactive to identify this and then educate the community. So that is the primary purpose of this OCR audit. Right, and then how do they? What kind of entities have been selected? It's like wide spectrum, right? So it could be a provider or a health plan, healthcare clearinghouse, and then again, like the sampling also included based on the size of the entities and what kind of affiliation. And the entities covered entity, business associate, or hybrid entity, and based on the locations geographically, how they are located, whether it's a public, private, nonprofit type of thing. So all these factors were considered according to HHS before they came up with this entity names, right? And then they went through this randomized algorithm to draw this whatever, like the 167 entities. The way they went about this is like they identified these 167 entities, and then they were required to provide all the business associates they are, doing business with, and then like they will identify the business associate, or they have identified the business associates from that pool to do the audit, right? So. But the good thing about this desk audit is they kind of narrow down, because if you see my earlier slide, there are the original OCR audit protocol had several requirements in place, and that's pretty exhaustive list. And so what they are doing is they are trying to, based on the phase 1 audit, they've identified about 7 areas where they want to focus more, and then those are the 7 areas actually they are requesting additional information on. So I have a slide that talks about those 7 areas. I'll get to that shortly. But essentially here, if you see all the 7 areas covers the security, privacy, and the breach part of it, and then on-site audit is going to start pretty soon. I think like some of the things we've already covered. They've got covered entities have about 10 business days to submit all the required documents, and if they need additional time, they could always. I remember one thing though, probably it's just a tip to the folks on the call. Always you could get an extension for submitting all your documentation as long as you have a solid business justification. Let's say you're going through a business cycle where you won't be able to focus a lot on this particular audit. You will be able to, provide that justification to them and get an extension. And most of the time what we've seen is, if you are going to be engaging an attorney to work with OCR HHS, it works out much better instead of you directly contacting them. The reason being, most of the folks that you eventually end up handling in HHS OCR is going to be attorneys. So, attorneys, they talk better among themselves. So you definitely want to, depending on your situation, of course, and budget, you want to engage an attorney to talk to HHS or OCR for extension or for whatever, interaction you have with them, because everything, whatever you send to them gets recorded, and that's pretty much and documented. So that's pretty much they are going to be using against you in case if they have to come after you, right? So I think like a lot of the information I've already shared. I'm not going to be repeating the stuff. So yes, I think even some of the things here has been already shared. So there is going to be two set of requests. One is listing your policies, procedures, and all the documentation that are required. And then the second one is the list of BAs that you are doing, business associate that you are doing business with, right? So they sent out two set of emails. And then if, as I mentioned earlier, if you are not able to submit the required information on time or with detail, so you need to provide the explanation for the deficiency in your response, right? So what happens after the audit? I think that is a $1 million question, right? So they have not been very upfront in terms of what will be the next step after the audit. But phase one audit, as far as we know, there were no specific actions given to the entities, or like there was no civil money. Let me correct it. There were no civil money penalties or anything on the entities that were selected for phase one. So probably they would, but essentially what will happen after the audit is they will have the draft findings of everything that they have gone through, and they will send the draft finding to you. You will have about a month or so to respond to that draft finding, whether you kind of agree to that. Oh, by the way, actually, these documents we were not able to provide in the first cycle, and here is what we could provide and stuff. And then what they do is with that draft finding, they kind of finalize their final documentation that is called final audit report, and then that is used for that is used as the final reference document for any compliance review or CMP, civil money penalties, whatnot, right? So first draft finding, you will be given time to provide your responses, and then the final audit will be generated by them. And then final audit will be used for any kind of settlement, whatnots, right? So the future. So that's the way it works. And here are the 7 areas that I talked about, right, on the privacy side. So they are definitely looking at the notice of privacy practices and what kind of content you have, whether you are clearly specifying where you would use their, where you would use patients' data and under what condition you will share it for marketing purposes and stuff. Those are like some of the things that they are looking at in 520, that is 164-520. And then in terms of provision of notice, they are also looking at, whether you have made them available in an electronic format on your website or, via email or whatnot, whether your patients are requesting them to be provided electronically and all those things. They are going to be looking into that part. And then right to access, they are going to be looking at the forms that you are collecting as part of your patient registration. what kind of access restrictions that you are making them available for the patients to say, okay, so under certain circumstances, your patients can request that they cannot, they don't want to share that information with a third party and things. So with respect to the breach notification, they are going to be looking at, they are also asking, if you had a breach and when did you send the notification, when did you discover, and show me the sample of the notification that you sent out. If you didn't have any breach, that is good. You are just going to attest saying that, you didn't have any breach, you didn't discover any breach, right? And then with respect to security rule, they are looking at your risk analysis, definitely, technical security risk analysis, and also they are looking at your risk management. So how is risk management different from risk analysis? So risk management essentially is all the identified risks from your risk analysis needs to have your management's review, and prioritization of this risk needs to be done, and then management review, and then time. When are you planning on fixing it, the date to fix it? All this information they are looking at with respect to your risk management. So they don't need all this information in a certain format. It could be in any format. Let's say you decide to do your own risk analysis, that's absolutely fine. But they are looking at some of this essential information to make sure that, your management knows about the risk, and then they have identified, they prioritized it, and they have assigned somebody to fix those issues by when. Right? Those are all the information that they are looking at. So what do we recommend in terms of handling these OCR audit requests, and how would you go about it, right? So we essentially recommend these 5 focus areas for any entity, whether you're a business associate on the call or a covered entity. We recommend these 5 different areas for your focus. So let's look into each one of these areas in detail. First one is the policies and procedures. So most of the folks now are migrating to a cloud-based system. So if you are migrating to cloud-based system, then the patient data footprint is really, really limited in your practice, right? Still, they are requiring you to have the physical security policy, whether you are maintaining all the records of the movement of the devices or any devices that is storing this PHI, and whether you are maintaining records of all the disposals of these electronic devices, and then whether you are maintaining the access request that is coming in for the devices and things. So these all could be essentially a policy document, and also forms that will have all the information of some of the things that we are talking about now, right? And then in the information security policy, what kind of access you will provide and what kind of roles you have defined, security groups, whatnot, and then how will you go about terminating an account, and all this information they are looking for. And then the password policy and how frequently you'll change the passwords and all this information, right? And then sanction policy, again, they want you to clearly define what is going to be your sanction policy in case any of your staff violates your policies, and then how would you go about communicating that to your staff, then have them acknowledge the sanction policy and things. Contingency plan policy is kind of a pretty big one when it comes to Hipaa. So essentially, in case if your primary system or the primary site goes down, what kind of plan you have to manage, to provide patient care when your systems are down, whether you will switch to paper-based records or whether you will set up a secondary site where you will copy all the data back to the secondary site and restore the service there and whatnot. All this information needs to be documented in the contingency plan policy. And then the last one is the security incident procedure. How would you go about reporting the incident? How would you go about investigating that? And how would you go about documenting that? So essentially, the way you want to see the audit is it's mostly about documentation. of what you would do, and how would you handle the situation. As you could see, this could get like really out of control because they are looking into a lot of different things. What we use is, especially whenever we do consulting, like we use templates to make sure that, we don't spend a lot of time reinvent the wheel for every practice in terms of this different procedures. Rather, like we use a template, update the required contents, and then make them a quick security policy, privacy policy, unless, the setup is really, really complex and, we need to start from scratch. And most of the time, like the templated version of the policies works with some updates. So I would recommend, definitely start out with that, and then if you are not finding the templates to be very suitable for you, to come up with your own. So the security, privacy, and breach, for all of them, you might want to consolidate everything and put it in one master policy so that, one, you can develop these policies quickly. Second, you can share that with your staff. Third thing, get acknowledgement from your staff to make sure that, they are going to abide by your policies, right? So those three things are essentially must. It's just not enough to have just the policy in place. It needs to be first approved by the management, and it needs to be implemented. And last one is it needs to be acknowledged by all the staff who are handling patient data. Second part is documentation. Essentially, they are going to be looking at your privacy and security notices. I think like some of the things we already talked about, notice of privacy practice kind of thing, and then what kind of requests are coming in for record access, and then how are you releasing it and things, and then the training logs. This is like one of the most important things. And then the PHI chart access review. So this is like kind of user audit. Let's say if you have a VIP patient to your practice, and if people get really nosy, if your staff get really nosy, they are looking into the detail of the chart and things, then whether you have a proper process in place to review your staff's activity and, identify any unauthorized access and things. I think the last point, the potentially up to 6 years worth of documentation, is something that we covered already. So the training covers actually a couple of areas. One is like all the Hipaa basics that we talked about already, and also it has to be generally a security awareness training too, in terms of now ransomware is very, very prevalent in the market. So your staff needs to be aware of how to handle ransomware, meaning at a very high level. They don't need to know the details of how the ransomware works, but they need to know, hey, what is ransomware, and what do they do in case if they get hit by a ransomware. And again, the phishing, email phishing is very, very prevalent still. If they get some weird email from somebody, some banks or some agency, then making sure that they don't click on it, provide the username, password, which pretty much opens up everything, right? So those are like some of the things actually you need to cover as part of your training. And also depending on the roles, you need to emphasize certain information more than others. For example, senior management, they are more focused on penalties and what is the high level rule and other things. But if your security and privacy officers need much deep dive training on what is happening, meaning like what is that they need to do, how to maintain, how to comply with the Hipaa and all those things. But it's the end user who's just collecting data, collecting patient data, handling patients. They need to know at a very high level when to release the record, or like when to escalate the issues to your Hipaa officer, privacy officer, or security officer, and kind of thing. IT team will have more technical security training, right, in terms of how to do the encryption or what is really required as per Hipaa, and whether to protect your Wi-Fi network or not, and all this sort of thing. So that's the way actually we see the training part of it, and depending on, based on the role, based on the need, we will have to customize this training. And then this is like one of the easiest one you could do today, right? Going back to your practice and figuring out all the vendors that you are doing business with, figuring out whether you are sharing this protected health information with them or not. If you are, then actually they have to be under the business associate contract. If you don't have one, making sure that you have one business associate contract with them is the easiest one you could do. Two things. One is if you are sharing patient data, the PHI information, without having business associate agreement, you are violating HIPAA. That is number one. Number two, you are completely transferring your liability to the business associate once you have this agreement, right? And of course, like we in the settlement examples that I showed you earlier, we do have cases where entities were penalized because they do not have a valid business associate contract with the vendors they are doing business with, but they just share the information, right? So definitely those are like some of the things you want to keep in mind, but keeping an updated list of the business associate vendors that you are doing business with, and then making sure that you have a contact with them is going to be the easiest one you could do today. And then we are not going to get into the detail of how to go about this technical security risk analysis, but essentially I'm going to cover at a high level what are the important things that you need to keep in mind. So we talked about those three safeguards: administrative, technical safeguards, right? What you need to do is when you go through like your EHR system, your desktop, laptop, your network, and whatnot, like all the other devices that are handling patient data, once you identify the risk by reviewing, let's say you are storing some patient data, downloading some Excel report or PDF report into your laptop, and that laptop is going with the staff to their home, and then like they might even take it to some remote sites to connect from there to your site or like to your cloud-based system. That means the risk is really high in this particular case example, right? So you want to make sure that you put that risk in a high category if it is not encrypted, right? If the laptop is encrypted, even if you lose your laptop, you don't need to report. That's a good thing about data breach. Let's say if you have done your data breach discovery and figured out that you have lost some thumb drive or laptop that contains protected health information, but that laptop is encrypted, so nobody who's getting hold of that laptop or the device will still not able to read that information, so you don't need to report it. That is kind of a common sense approach, right? So same thing, you want to kind of identify the risk and then put them in different bucket, high, medium, or low, and have some action plan and then target date to fix this thing. The good thing about HIPAA is, not many people are going to say this. Good thing about HIPAA is they don't want you to fix all the issues today. All they want you to document is what are the risks you identified as part of your security risk analysis, what is your plan, and when are you going to fix it. Let's say you identified some high risk and you kind of given yourself about 3 months time or 6 months time to fix that issue for so and so reason. You pretty much can justify that to any auditor. And they are not going to come back and say, hey, why you didn't have a month time to fix this issue? It's a 6 month, right? As long as you could justify that's fine. And the same thing with respect to the whole, all the risks that you are identifying. You don't need to fix it today. And all you need to have is just a plan. And of course, like they are going to be, let's say if they are going to be coming back next year, audit is going to come back next year to do the assessment, they're going to be looking at, hey, okay, last year you said like in 6 months you're going to fix that issue. By now you should have fixed it, so what's the status, right? Those sort of things they are going to be requesting. So what are like some of the key takeaways? I know like we've got a few more minutes to wrap up. What are like some of the key takeaways from this presentation? So desk audits are underway. I shared that already with you. And then OCR is basically going to be auditing based on the documentation that you're submitting. If you don't have documentation, then you are in a very big disadvantageous position, right? So, excuse me. That's why we recommend, excuse me. So that's why we recommend document everything. Whether you are doing a security, it doesn't need to be in certain format. That's a good thing about it. And as long as you document your analysis, security analysis or training and other things, then like you have something to show them that you are doing your due diligence to comply with Hipaa, right? And auditors all understand that, nobody is perfect. And then as long as you show your seriousness and show your due diligence in terms of complying with this thing, you have a pretty good case to prove that, you are in compliance. And so business associate desk audits are going to be starting pretty soon. And then comprehensive on-site audits is starting early 2017. And then the three things that you need to keep in mind: policies, documentation, and risk analysis are the key areas. So if you don't have these three, then it's very, very difficult to prove yourself that you are complying with this law. And then there is actually no silver bullet, and it's a journey of continuous assessment and improvement. And so planning, I think like I kind of stress on that already as well. And the planning ahead is the key, because they are not going to give you a lot of time to provide all this documentation and things. There is plenty of information available, guys. To go to HHS website. They have a separate audit protocol program overview site where you can look into all this information. They have frequently asked questions and all this information. And if you don't have time to educate yourself on all these different things that are happening, of course, you have consultants like us to help you out. With that, I am actually going to wrap up and then open it up for questions. Kishore, you there?
Yeah. Thank you, Srini, for the presentation. Now we will open the lines for Q&A session. Anybody having a question can raise their hand by clicking hand button, which is down right corner of your screen. Also, you can send your questions in the chat window.
Yeah, so Kishore, one question actually I've been being asked frequently is, what is the next phase of OCR audit? Phase 1 is over, phase 2 is going on, and what is the next phase? So with the new administration taking over, new leads for most of these agencies, CMS, HHS, so there is going to be, it's kind of, there are a lot of moving parts. At this point, we are not getting any clear guidance yet. But essentially, if not today, you need to comply with Hipaa anyways, Hipaa and HITECH rules anyways. And the second thing is you need to provide documentation for 6 years. So in my opinion, you really don't need to wait for their direction in terms of the audit and things. But based on some of the trends and the signals that we are getting from them, looks like, they are going to get more active and more aggressive in some of these things. And also, if you see the settlement amounts for a lot of the agencies, with a lot of the entities, it is big amounts. Like it's at least few $100,000 for small entities to millions of dollars for big hospitals, right? So, and it is kind of another way to self-fund these agencies, HHS and OCR audit agencies and stuff. So you definitely, in our opinion, it's not going to go away. It's probably, if not increasing, or at least it's going to stay this way. I don't know if that helps. Yeah. Yeah, I'm done, Kishore.
Yeah, it seems there is no questions at this moment. However, you can still send your questions to email ID at webinar@compliancekey.com. With this, we will end the session. We appreciate your time and believe the session was informative and up to your expectation. We look forward to see you in your next event. Soon you would be receiving certificate of attendance and a feedback form. Kindly send your comments. Your feedback is important for us. Thank you very much for your time and have a good day. Thank you, Srini, for the presentation.
Thank you. Thanks for the opportunity as well, Kishore.